the law provides that even during the pendency of the proceedings, there are certain rights that a complainant has. Okay, and the biggest fear for any complainant is what will happen. Once I file a complaint, everybody will be like, pointing fingers at me, or I will face a hostile work environment. Or it could be a fear qua the accused only. So, in that sense, the law provides that you can request the ICC, and ICC can make a recommendation to the employer that in the given situation, the complainant should be transferred to, say, another department, or she can be transferred to another unit, like whatever makes her feel comfortable, or she can even go on a leave during the pendency of the proceedings. Because and that leave will be over and above what she's entitled to in the normal course, right? So these are the provisions that women can avail of during the pendency of the proceedings.
Sometimes in sexual harassment cases, we also come across cases where there's absolutely no evidence. It's my word against your word, and then what do we do at such a time? So the burden of proof is always on the respondent in such cases, and if the woman is saying that she's been sexually harassed, we have to give her the benefit of doubt. In 2016 or 2017, there has been a judgment even from the Delhi High Court that says that when you talk of principles of natural justice, it is where the woman has to be given the benefit of doubt, and the respondent has to prove that I have not done this sexual harassment.
It could have happened in a private place where you don't have anybody to sort of attest to what you're saying. But one standard of proof that is often used is the people around you that you've gone and spoken to, and they can always come forward and support their version, your version of what happened. Otherwise, it is mostly he said, she said. At the end of the day, when we talk about sexual harassment, even it is about the impact that is there on the woman concerned. It is not so much about the intent behind the conduct or the act. So, one standard that ICC applies to complaints that come before it would be if something can be one is of course like reasonable person. Something that is said, it has, if it is offensive to a reasonable person, it is offensive, like we're not talking about an extra sensitive person, but otherwise the second aspect of it is the impact that it creates on the person concerned, and the excuse that I did not mean to say these words with that intent cannot be taken by the accused person or the person who's being blamed for bad behavior.
What Vishaka did, I mean, one of the highlights of Vishaka guideline in 1997 that set this whole discussion about sexual harassment at workplace was that it shifted the burden of keeping the workplace safe from an individual to an organization. And hence the employer plays an important role in following the mandate of this law. There is an entire section in the law that talks about what is it that the employer needs to do, like put up boards at various places saying that this place is zero tolerance for sexual harassment, or giving those messages about where can you go and file a complaint, who are the committee members, what does sexual harassment mean, so that as soon as somebody enters the office premise, the work premise, they know that this workplace does have a committee. Now, if the employer does not follow the mandate of the law, there is a fine. The first offense is a fine of up to 50,000 rupees. A consecutive offense has a fine up to 1 lakh rupees. So much so that the appropriate authority can also withhold or cancel the registrations of these organizations. Now, I have worked with both, the corporate sector, education, government, non-government, all of it. I generally have seen this kind of a pattern that the government organizations are not really bothered about this whole penalty part of it, because it doesn't go out of their pocket. Also, you can't stop that department. It is still there. Private organizations are in have this whole fear that what if somebody fines us with 50,000 rupees or cancels our registration. But nonetheless, there are certain efforts that are being taken even in the government organization to check that everybody knows about this law and there's awareness about it created. Now, most of the time when people think of awareness, because that's one of the mandate, and if you look at the title of the law itself, it is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. So if we focus on the preventive part of it and prohibitive part of it, we don't really need to go to redressal, because then we are already taking efforts to make that workplace a safe workplace. A lot of organizations think that, oh, it's about women, so the trainings have to happen only for women, or the awareness has to be created for women. But that's not so, because it's not just about whom you are working with in your premise. If you are working with a client outside your organization, if you're working with a vendor outside your organization, that's still a working relationship. right? And so even so this brings me to the point that diversity and inclusion is so much important. So a lot of people have asked me, oh, we are all men organization, how do we form this committee? Because to form a committee, it has to be headed by a woman at a senior position. So I said, okay, then write to the it would be good to have women in your organization, at least to comply with this law. But if you don't have, write to the women and child development department as a nodal agency for implementing this law and ask them what they have to do, especially if they don't have a sister concern and then there are no women coming out. This is a gender issue basically. Sometimes there are cases that on the face of it look like a sexual harassment, but they're not sexual harassment. There are any other kinds of harassment that don't fall under the purview of this law. That's a very thin dividing line. And so I said that we have to look at every case in a context and not in isolation of certain incidences that have happened. And so inclusion of men in the committee is equally important. A lot of organizations ask me when they form a committee that can we form an all women committee? I said it's up to you, you can form. But if you ask me, I would say that you include men because getting their perspective of all this is equally important. Now, when you file a case, whenever you make a gender specific law such as this law, a lot of people have this whole understanding that, oh, you made a law for the women, which means it's against the men. And that's not true, because if you look at the definition of respondent in this particular law, it says any person against whom the allegation is made. So now this any person is a gender neutral definition. And I have handled cases where there is a case of a woman against a woman as well. And now understand this, that this is basically coming from power equation, or rather an imbalance in the power equation. And hence when you create an awareness, it has to be both for men and women, so that women are assertive about talking about sexual harassment. Because a lot of times, even though the organization has a very proactive committee, women may be scared of losing the job, or character assassination of what people will say. Why is it only happening to me? So they go on a big guilt trip, and we have to keep on telling them that it's not your fault. Something has happened. It's important that you voice it. So women need to be assertive if they're facing a violation, and so also men need to be sensitive. And we cannot generalize that all men are not sensitive, but to create that awareness, not to scare them, but to say that you are equally part of this organization, and a work environment has to be safe and healthy for everyone, including men. And we need to take those proactive steps to make it healthy and safe.
What do we mean by conciliation? And I've seen this getting used a lot. People, ICC members say, oh, this is nothing, let's try and concile the matter. Let's get both the parties to sit down. We'll make one apologize. Now, the law has a provision for conciliation. It says that before you enter into conducting the inquiry, you need to explore the possibility of both parties seeing eye to eye. Maybe that involves, one of the party apologizing privately, publicly, howsoever. It does not involve money. It should not involve money, exchange of money between the parties. But that is only when, only before you enter into an inquiry. So if ICC initiates an inquiry, to my mind, there should not be any conciliation, because that is moving a step beyond, and that is accepting that yes, there is a prima facie case which needs investigation. Conciliation is something that cannot be forced on somebody, but yes, it's a way out, because a lot of people are fearful of what will be the consequences if they file a complaint. So you always have like this midway where you can tell the person concerned that what you're doing is not okay. You inform the organization as well, and the organization, without going further, gets involved in the matter to redress. It's like a meeting you halfway, where you send out the message, the abuse or the harassment stops, without really going through with the entire process of calling people, giving evidence, etc., etc. So yeah, so conciliation is something that we all need to be aware about, that it is a midway point, and you still have an option. Once you file a complaint, you can still tell the committee that I'm looking for a conciliation proceeding where you can assure me that this will not go further, and the accused can come forward and he can apologize, and things can end there instead of getting into the whole process of investigation or inquiry, as we call it.
So yeah, conciliation is one of the process, and that can be initiated only if the aggrieved woman or the person making the complaint wants. It is on the premise that sexual harassment has happened. There are prima facie, on the first look of it, there are evidences to show that, and only then that's when we kind of suggest, we give that option to the lady, but she has to really take it. Now, we have to understand that the law does not mandate conciliation in all cases. The word used there is may, and so it is still the discretion of the woman to whether opt for a conciliation or not. And I have done a couple of conciliations, and that's not just about apology. It is basically about making her feel safe, and there could be many other remedies that we can look for in conciliation. If conciliation is not an option, then it's an inquiry. When we do an inquiry, it's like a court process because the internal committee has the powers of the civil court. And so in an inquiry, we look for circumstantial evidences, we look for documentary evidences, we look for witnesses. Sometimes we ask the parties to, get their witnesses. Now, if they don't, sometimes in an office environment, there's a likelihood that somebody might say, oh yes, I've been a witness, but I don't want to side anybody because I want to maintain a neutral position. At such a time, even if the name of this person is mentioned either in the complaint or in the reply, we can always call that person as a committee's witness and get more information from this person. So I definitely, in the time that I have, I cannot go into the details of how the procedure is done. But yeah, documentation of it at every stage is very important. There would be times when the lady or the respondent may not be able to get a particular evidence because the committee has the powers of the court. They can always get those evidences, especially documentary evidences, from the concerned department if they have to really check that as part of evidence. Natural justice, principles of natural justice has to be followed, and so it is basically where a fair trial happens, where both the parties get a chance to put across their case. Lawyers are not allowed before the committee, so it is the duty of the internal committee to help the parties that they are able to represent themselves well.